Sikshayati, platform for eminent authors, engaging teachers, successful students. To know more, email. Quasi contracts. Quasi contracts are contract-like relationship created by law even without entering into a contract. In some cases, a legal responsibility emerges even without entering into a contract by any party. No offer or acceptance. It is based on the principle of equity that no one gains at the expense of another. The term quasi means similarity or resemblance. Quasi contracts, though not contracts, are named so because even without entering into any contract, a legal relationship comes up with enforceable rights and obligations attached to a quasi-contract like a contract. Strictly speaking, a quasi-contract is not a contract, as a contract is intentionally entered into. So, quasi-contracts are sometimes called as contracts implied by law. Instances of quasi-contracts: supply of necessaries. Sometimes a person is legally bound to support another incapable person with incapability like minor, etc., with necessaries suited to his condition in life. The person providing the supplies is entitled to be reimbursed from the property of such supported person. Necessaries means necessaries suitable to the conditions of life of the person to whom such necessaries are supplied. Food, clothing and housing, education expenses, medical expenses, legal expenses for defending minor in civil and criminal proceedings, etc. are considered necessaries. A loan taken for purchase of necessities shall bind the incapable person. A fund supplied to a minor for the marriage of a female member of his family is considered as necessaries of minor. Payment by interested person. A person, to protect his interest, makes payment on behalf of someone which was legally due, is entitled to be reimbursed by the person. The payment made should be bona fide for the protection of one's interest. The payment must be such as the other party was bound by law to pay, should not be a voluntary one. A left his carriage on B's premises. B's landlord seized the carriage as distress for rent. A paid the rent on behalf of B to obtain the release of his carriage. Held, A could recover the amount from B. Example: the goods belonging to A were wrongfully attached on account of arrears of government revenue due from B. A paid the amount to save the goods from sale. Held, A was entitled to recover the amount from B. Non-gratuitous act. When a person lawfully does anything for the benefit of another person, not gratuitously, the person enjoying the benefit should compensate the person. Example: X, a tradesman, leaves goods at Y's house by mistake. Y treats the goods as his own. Y is bound to compensate X. Finder of lost goods. A person who finds goods belonging to another and takes them into his custody becomes like a bailee of goods and acquires legal rights and duties, for example, particular lien on the goods. The finder of goods must take care of the goods like his own goods. He cannot mix the goods with his own. He must take steps to trace its owner. If there is any accretion of goods, like a cow gives a calf, he must return the accretion. The finder can sell the goods in his custody if the goods are in danger of perishing, or the owner refuses to pay his lawful charges in respect of the thing found, or the charges amounts to at least 2/3 of the value of the thing found. Example: X gave his gold jewelry to Y for safekeeping. Y just kept it in his drawer without lock and key. It was stolen. Y is responsible for the loss as he did not take proper care. Example: X gave his gold jewelry to Y for safekeeping. Y kept it under lock and key. Next day, the jewellery of Y along with jewellery of X were burgled. Y is not responsible as he took care of X's good as his own. Example, X finding a diamond in a diamond shop gives it to shop owner asking him to give it to real owner. The shopkeeper could not find the true owner. The original finder is entitled to get back the diamond because he is the nearest person after the true owner. Mistake or caution. A person to whom money has been paid or anything delivered by mistake or under caution must repay or return it to the person. Example, A and B jointly owe rupees 100 to C. A alone pays the amount to C. B, not knowing the fact, pays rupees 100 over to C again. C is bound to pay the amount to B. Characteristics of quasi-contract. Imposed by law. A quasi-contract does not arise from any formal agreement but is imposed by law. The parties are put in the same position as if there were a contract between them. Equity. Quasi-contract is imposed by law. It is subject to the principle of equity. No one should benefit at the cost of other, and good conscience. Thus, duty and not promise constitutes the basis of a quasi-contract. Rights and liabilities. It grants a right to one party and imposes a liability on the other party in connection with the benefit already received. The right granted to a party under a quasi-contract is not available to him against the whole world but against particular person only. In this respect, it resembles a contractual right. Breach. When an obligation created by quasi-contract is not discharged, the aggrieved party is entitled to all remedies available for breach of contractual obligation and also to compensation in the same way as if he had made a contract on the other party broken it. So, a suit for breach of a quasi-contract may be filed like normal contract. Thank you for watching the video. Kindly write your comments. Click on the red subscribe button at the bottom of the video to get more details and free ebook. Email us.